Good afternoon. Hello there. Haven't seen you guys in a while. Of course, I can't see you really. I could see names. Welcome to everybody. Hope everybody's well. I'm going to bring you up to date on at least give you a quick summary on the receiver's 6th interim report and the status conference that happened yesterday, just to bring you up to speed, and also bring you up to speed a little bit about what Forster indicated to me in a text. And I guess he had some conversation with the attorneys for the receiver, or at least attempted to. I don't know what it became of that, but we'll go through all that. Not legal advice. Like, subscribe, share, comment, drool, whatever you think is appropriate. Please share with everybody in the universe also, please, if you could. Quickly, once 8 o'clock, it was just very time consuming. Some of the stuff, it's difficult for me to read my own writing. So the best way to find a cure for itching is to start from scratch. I just lost my mood ring, and I don't really know how to feel about it. And last but not least, did you hear about the new restaurant on the moon? The food is great, but the place has no atmosphere. Anyway, yesterday, there was a hearing yesterday in Las Vegas, a status conference. It was 4:30 p.m. Eastern time. I attended. I guess I appeared theoretically because my appearance was announced. The new attorney for a group of, I think it's 41 plaintiffs, 41 shareholders, I think it was 41, appeared through their counsel, and I've had communication with their counsel also. But most of the entirety of the hearing was the attorney for the receiver talking to the judge and kind of going over the receiver's report. Now, prior to the hearing, I filed a declaration, and in the declaration, I focused on the issue of the audit. So coincidentally, about, let's see, the hearing was probably about an hour, I would guess, maybe slightly more. Dylan Siciliano was the prime speaker at the hearing. I think almost entirely was him. He gave a long discussion, and just as it turned out, he focused on the audit amongst everything else. He also kind of gave background as to the difficulties in this case and shareholders and how great a job the receiver done, etc. So he explained, and I listened very carefully, and kind of the idea of filing the declaration was to make the audit a central point of discussion. And I figured if you make a point of it, whether it's done or not, it will expedite the conclusion. And if you look at the receiver's report and what he said yesterday, there's one issue that remains, and it's a GTI, not GTII. It's some kind of gold company that the transactions and the accounting were very difficult to follow. He first went through the issue of how the audit has been delayed, and he agrees it's lasted longer than expected. And he also indicated that he believes that this one last issue is the last issue, and he's not willing to make a declaration as to when the timing, because he doesn't want shareholders to be able to use that information, the shareholders who can trade. But he kind of laid out what the main delay is. And just to refresh everybody's memory, the audit was started, or the primary auditor for GTII was Borgers, and they were scumbags, and eventually they got kicked out by the SEC. In about September of 2024, the prior management hired Fortune. The receiver, when they were appointed in September, continued to use Fortune from September of 2024 through January of 2025. In January 2025, they discovered that Fortune really wasn't working out. Let's just say that. They then brought in another, their own people, who they say they've worked with for quite some time. that party is still finishing up the audit. Now, one problem that arose, and it wasn't addressed yesterday, but I wasn't going to beat a dead horse because the judge didn't seem to be particularly interested after the explanation. They hired the firm that's doing it now, so they hired somebody. That person is on maternity leave now. So I would guess when they hired them that they may have known that. Maybe they didn't know that, but if they knew that, then they probably should have taken that into account. If they didn't know that because the person wasn't pregnant at that time, then so be it. I don't know specifically when the person had to take leave, but they probably should have followed up on it if in fact it was discoverable, because if they knew that somebody wouldn't be able to complete the project, they probably should have gone to somebody else. But be that as it may, once that person took maternity leave, there were another group in the same company that had to take over. They did, but they couldn't just rely upon the work of the person who had taken maternity leave. They had to redo the work. So that's been a delay. And the explanation for why it's taken so long is the books suck. There's lots of questionable transactions. And besides the fact that they haven't got the cooperation from the needed people they needed, they blame the attorneys who were the prior attorneys for GTII for the delay. They say usually, they can rely upon what the attorneys say and what they do, and that expedites things. But in this case, because there's a bunch of backdated documents, backdated contracts, all kinds of screwy transactions, and that's my term, based upon what the report says, they couldn't rely upon what the attorneys did. In fact, I think he referenced that at one point in time during the hearing that they're considering bringing RICO charges against some of the attorneys. RICO, fraud, I don't remember what else they referenced, but claims against the attorneys for all kinds of misdeeds. And I think I reported on one of the depositions that I attended involved, and it's in the report, so it's involved Markowitz, and apparently one transaction that was pointed out in the report relates to the transaction with Tommy Wang, where there's a 10 million share transaction. Money is paid $2 million. 1.8 goes to David Reichman. It apparently should have gone to GTII, and Markowitz took out 200 grand as his fee for what, I don't know, but as his fee. And that looked like perhaps that's not a proper transaction. Let's just leave it at that. But there's a whole series of those transactions, so they couldn't rely upon it. So as a result, this has taken the auditors a lot longer because they had to go back. They had a screwy auditor. They had a auditor that got suspended, and they had to kind of redo a lot of the work. Is it at the speed I would like? No. And I would have liked them to explain that, and I asked them to appear. They kind of poo-pooed that, and they didn't appear. There will be another, I'm going to talk about one more thing. There's going to be another hearing, a status conference, March 19th, I believe, and I'm hoping by then that the audit is done. So that's kind of the idea. The GTII gold transaction, so it's not GTII, but it's GTII, which is a subsidiary of GTII. And apparently there's a bunch of people who are connected to GTII that are also now connected to GTI. There were, there's a bunch of mysterious entries. They're trying to figure out a way how to account for it. There's a bunch of debt apparently that's on GTII's books related to GTII. They want to get rid of it. But there's a certain standard that the accountants need in order to get there, and they haven't reached that. So they're still trying to process it. They've asserted that that's the only, or they've asserted that as of now, that is the only remaining issue that needs to be taken care of. Now, you've heard that story before. If you recall, at one point in time, they needed certifications, and the indication was after the certifications, or at least my impression was that after the certifications, and I'm not the only one, by the way, but after the certifications were done, that the audit would be done. And that's like many months ago, but the certifications were done and we're still not done. But apparently now we're at the very end, and this is the only issue that's remaining. They didn't talk about any corrective action that they were supposed to have taken. So perhaps they haven't. But they've indicated this GTII gold transaction is the last major issue stopping the completion of the audit. And after we get the audit, we'll have to examine the audit and its contents. So audit, they basically said we're at the end and we're expecting it anytime now without being specific. If they don't have it by March 19th, I'm sure that there'll be a stink to be made, but I'm hoping that by March 19th it's done or basically done. They're not going to tell us beforehand. They're just going to make a filing, I believe. They'll file a SEC filing that'll indicate that the audit has been complete. That we will have it at that point in time. And obviously, without the audit, there's nothing that can go forward in terms of transactions with the company or moving forward, period. Now, one of the things that came up during the hearing, I don't think it's referenced in the report, was the receiver and the receiver's shares. And they talked about the number of shares they've recouped since they began. So they've recouped about, over $1 million. They've recouped 21 million plus shares. They have 40 million shares that I think they're going to get back because those were contested shares that they did not get any opposition for. So the way it was portrayed in the hearing is those will come back. So that means and there's going to be Kathy Griffin shares also. It's 11 million shares. So that's a total of approximately 50 million shares. He also indicated, so that's 50 plus the ones they got, the 21, that's 71. Plus they indicate that there's about another 60 million shares that's subject to settlement discussions. So their premise was they will be able to return, and this, I would say this is a good thing. I'm not going to say anything differently, that they'll be able to get about half the shares back. So the float is about 300 million, apparently. And the numbers I just threw out, I think it was about 130 million. They said about half, so maybe it's 150. We shall see. If they're able to bring back 150 million out of the 300 million shares, that's good for shareholders. If in fact this is able to trade at some point in time. If we can't trade, there's no business, etc., then it's kind of meaningless. But the one good thing that we have, and it's a plus and a minus, is the way the receiver's compensation is structured. He gets paid 10% of whatever monies are brought in, 10% of whatever shares that are canceled or brought back in. Based upon what the receiver's counsel was saying, and I was just adding up the numbers, if it's close to half, and I said 130 million shares, that would mean the receiver would get 13 million shares. Again, that would make him one of the largest, if not the largest shareholder. Is that correct? Should he be able to dispose of those shares? I expect the next time that there's a compensation request that these issues will come up. In my declaration, I raised it, but I indicated that's not really before the court now anyway, because there's no compensation request. But we have to think in part that the receiver, if the receiver's counsel is correct, will have received somewhere between 13 million and 15 million shares. And should he be able to sell those shares before retail? Should there be a pause? Should this be reflected in an agreement? I think all those are true, but it hasn't come up yet. But I expect that the next time there's a request for compensation, that will come up. And obviously I will file a brief like I did this time, indicating my opinion as to that. And perhaps other counsel will be filing briefs also. Did reference that they just signed a stipulation and order allowing Reichman, being David, to have $10,000 to be used for attorney's fees for a real estate purpose. I asked what that purpose was. Mr. Siciliano was unclear, other than the fact he said it relates to a settlement with GTII. So by that information, it sounds like, and again, I don't know when and the terms, what they will be, although I think he indicated during the hearing that the conduct of Reichman would influence the terms of the settlement agreement. I hope so. But it sounds like that the receiver and Reichman are close to cutting a deal that will resolve the issues between Reichman and the receiver. It doesn't resolve all of Reichman's issues, but it will resolve the issues between Reichman and the receiver. And I can only guess that also would involve the return of shares, although it's not specific. And it also might involve the return of shares from third parties or other groups. By the way, so the GTII Gold, going back to what I was mentioning, part of the difficulty in the transaction is there was a bunch of loans that were made, and a lot of the lenders are deceased. The lenders would get shares in response. There's just not a lot of people talking. So $10K to David Reichman, I know that's appalling, makes you sick. I know, because it makes my stomach drop. But if it's in part, the Receivers Council said it was Reichman's money because it was in his account. Now, whether that's Reichman's money or not is a different question, because we don't know where the source of those funds are. And there was transactions that are referenced in the Receivers report, the sixth interim report, where it suggests that the monies may have come from inappropriate means. But in the interest of getting a settlement, if the settlement is good and we can get moving on from that, and it helps return an inordinate number of shares, and if in fact it's a minor amount of money, even though it makes me sick to see Reichman get any benefit, I don't know if he's getting a benefit here other than a settlement of everything. So I think the monies will be released soon, and it sounds to me like a settlement or a potential settlement with Reichman is in the works, and we will know shortly. There was discussion about the shorts and shorting, and the receiver. This is kind of a bone to shareholders, I think. The receiver is making a point of looking up the Alpine issue. I think, as I mentioned, there are some depositions scheduled of Alpine individuals. And I know the concern amongst all of us is that there's naked shorting going on, et cetera, and inappropriate activities. They kind of indicated that they don't believe that the action of the stock was caused by the shorting. They think it was caused by the selling of management and the lack of liquidity and income. So the impact of making sales where you're having very little liquidity, very little revenue, et cetera, would be dramatic. So they don't think Alpine shorting or caused price to spike or to drop. Now, I don't know if that's true or not. I have my doubts in light of Alpine, but that's what they're saying. And I will be attending the depositions of Alpine to kind of to follow that up. They also talked about the Kramers, and the allegations were, and I guess people reached out, that the Kramers were responsible for some of the inappropriate shorting. They think that it was people impersonating the Kramers, and I guess they have a bunch of information and documents that I haven't seen, but that's what they asserted in the report, that apparently it was people pretending to be the Kramers and asserting that, and they've apparently met with the Kramers and spoke with them. That remains to be seen. I'd be interested again in seeing what happens at the deposition of Alpine. I will attend and, of course, report on that. But the receiver was pretty specific that they will continue chasing down the issue of shorting because they know that's important to shareholders. So I found that was a important issue. Last and not least, there was a discussion about the AI-versity. I'll talk briefly about the attorneys in a second. But there was a discussion about AI-versity and the ongoing transaction. And the way it was portrayed, and this is just my interpretation, but the way it was portrayed by counsel for the receiver, they kind of downplayed the transaction. So what they said, if I have it correctly, that if GTII was worth $100, Forster and AIversity was offering 8 to value it at 8, and that's all he said. And then I saw a text message from Forster. I think it was on X before I got hacked. I got hacked on X. I think I got hacked because anything I look at is black. Any of the boxes are black. I can type in something, but I can't see what people send me. And I tried resetting, whatever. So I think I got hacked. Is really what I think. Somebody must not like me. So if you want to respond to me, then respond to my tweets and I will try to respond. I think my tweets are still working. It's just my DMs on my private DMs don't seem to be working. So what Forster seemed to indicate, contrary to the 8%, I think that's what Dylan said, Forster indicated that, one, you have to value the assets correctly. So right now, GTII has basically nothing. It doesn't make any revenue. And AIversity, I guess, has something. And I think the valuation today, although don't quote me on this, was something on the order of $30 million, something like that. I think the valuation of GTII currently in its current state would be like 30 cents. So Forster, and again, this is just my impression, Forster has investors and they can't just give away the store. So they're trying to make a deal to provide, this is what Forster has indicated, they're trying to do a deal to provide GTII shareholders, the good guys, exit liquidity. And the way they're going to do that is, and I don't know what the final deal is, what the final numbers are going to be. I haven't participated in any of those, haven't seen any contracts, etc. But the way my understanding is that Forster will own 85% of the company, that he will agree, and it'll be in writing, not to sell for at least 1 year any stock. And he won't take any, there'll be no salary increases and no bonuses, and his investors won't be able to sell any stock for 6 months. So they will be kind of locked out. And the impression I got also was that the existing GTI shareholders will not be locked out. So they will be able to sell. So before Forster and his investors will be able to sell, they will give GTII shareholders a chance for exit liquidity. And if in fact, and again, I don't know, I haven't looked at any of the documents, any of the books, etc. This is just what I'm told, and this is what I'm speaking out here. If in fact Forster brings a company worth millions of dollars and matches it with GTII, I don't know, but my guess is the value of GTII would probably go up based upon that new entity. And even if it was 8%, it would be 8% of a much bigger number, because today 8% of 2 cents is not worth very much. But 8% of a bigger number might be worth something and might provide everyone an opportunity to either stay in or get out. But I think it's Forster's, and he can speak for himself, but I think it's Forster's intention, and this is what he's communicated to me at all times. This is not really something that's benefiting his company substantially. His interest is in trying to help out shareholders. If you watch, he's been on MMTLP also in the recent times. So I think his interest is setting up a transaction whereby everybody could get exit liquidity. Now, maybe that doesn't line up with the interests of the receiver. I don't know. The receiver, as I kind of indicated before, if he brings in 150 million shares, he'll have 15 million shares, and maybe he doesn't want that type of setup. Maybe it's not advantageous to him. I don't know. But if in fact it provides an option for, it provides a bump in value and then an option for liquidity. I think that's an interesting thing to examine when it arises. Alternatively, and the receiver kind of referenced it, the receiver's counsel referenced it very vaguely, that there might be other alternatives out there. And again, perhaps, but I don't know if there's other alternatives give a crap about the existing shareholders. Forster, unless he's not being truthful, has been consistently indicating that he's interested in the existing shareholders. The receiver, again, my concern all along, or at least over the recent past, is that his interest is in his own interest. He's doing his job, so they're doing the job of what a receivership should do, but I don't think that necessarily he has the financial interests of retail shareholders at heart. I feel differently about Forster, but all this is going to be before, at some point in time, it's going to be before the court and all of you, and you can state your opinion, and maybe a different or better deal will come about. I would just be highly suspect of it in light of the current condition of GTII. Trying to think of the report went into discussion about the various attorneys. It kind of focused on Markowitz, that one I mentioned. It also focused on another attorney who I don't really know anything about, Mr. Brook, who was, I guess, general counsel or acted as general counsel before Markowitz. And the receiver's report says that and he was involved at a time where the shares had a higher value. And I guess the receiver, in the report of the receiver, it intimates that, at least that's what I thought it said. So this is just my recollection. Could be wrong. So you read the report. But I think he indicated that this gentleman, who may have done a great job, by the way, through his workings with GTII, he netted something on the order of $7 million for his time and efforts. The receiver doesn't say that he is involved in, at least in my reading of the report, the receiver doesn't indicate that this guy was involved in any wrongdoing, etc., that he didn't know things. At least that's what he suspects, but that's what he generated. And he also talks about all those 144 opinions where those insiders are get an opinion saying it's okay for you to sell. Those are valid shares you could sell. There are a bunch of attorneys that did them. The receiver's report suggests that maybe not all of those 144 opinions could be relied upon or were accurate, and they were usually could be relied upon, but they were not accurate. I know that subsequent to the court appearance yesterday, that Forster did reach out to the receiver's counsel. I assume there'll be further communication. I don't know what will happen to them. The receiver indicated they had hired another law firm to examine the terms and present additional terms. But based upon what I saw from Forster, it appears the next court hearing that these issues will be addressed and the deal will be addressed. I think Forster also indicated, at least I think I saw, that he will put out the terms of the deal publicly and that everyone will get a chance to kind of review what the terms are and decide if they're interested or not. I think he indicated yesterday, listen, if the shareholders aren't interested, then they won't do the deal. If they are, then, and the court approves it and it can close, then they will do that. My concern, again, is the conflict between the interests of the receiver in his shares versus the interest of the retail shareholders. And that's kind of like, until we finish, we're not going to really know where the allegiances lie. So we talked about the audit, and again, that apparently we're at the end. We've heard it before. but we're at the last issue, which is GTI Gold and how to characterize that transaction. And that appears to be the last issue. We have a status conference on March 19th, and I'm hoping by then that the audit is complete. We will probably learn about the audit being done through a SEC filing, not by being told, but by a filing. We heard about the Alpine and the shorting, that they can continue to depose people and to see about if they could find out what went on, but they don't think that was the cause of the dramatic price movement. It was more the selling by insiders and the lack of income. We spoke about the $10K to David Reichman to hire a real estate attorney in California, and that it was, in essence, to complete the settlement with GTII. And if that's good, if that's the purpose, even though I detest giving Reichman anything, if it helps us get the shares back from Reichman and get him out of the picture, then so be it. We talked about the total number of shares that were going to be brought back by the receiver. That so far 21.5, additional 40 million that have been uncontested, 11 million from Kathy Griffin, and the receiver indicated that there's about another 60 million, the subject of settlement agreement, which adds up about 130 million shares, which is approximately 45%, approximately 45%, something like that, of the total outstanding shares of 300 million. Of that, just to remind everybody, the receiver would be entitled to 15 million shares, which I think is a gargantuan sum, but that's what the current deal says. I will certainly interpose an objection once we get to the next next time any shares are being, or compensation is being discussed. I will certainly raise the issue in a declaration. And then the last topic we discussed was AI-versity, the deal, what Dylan Siciliano said at the hearing, the 8%, and then how Forster characterized it, that it's different, that his shares basically are frozen for a year, that insiders are frozen for a year, and it provides shareholders, retail shareholders, an exit opportunity after an entity that has value is brought into GTII. So that's all I wanted to talk about. I have that's a skim job of the report and of the hearing, but it gives you enough detail to kind of understand what's going on. I will continue to kind of stay on top of pressing on the audit. I will appear at March 19th. I will be discussing this with new counsel for that group of shareholders. And I will be reporting on this. Since I cannot read my tweets from everybody, again, if you want to respond to me, just respond when I make a general tweet. If you have a question or something, throw it out there. And if you've contacted me in the past, contact me on email, etc. That's fine also. But for whatever reason, I don't have access to my tweets because it appears I've been hacked by somebody who doesn't like something. So I think that's about it. I don't have anything else much to say. Hopefully the audit will be done before March 19th. Hopefully we will have more depositions in the next couple weeks. Hopefully we'll get a settlement or a resolution with Reichman. Hopefully there'll be 130, 150 million shares returned, which will help with regard to dilution if in fact we're able to trade and everything moves forward. And again, the one good thing about the receiver being aligned with shareholders is if this company went bankrupt, the receiver wouldn't be able to sell his shares and wouldn't get his money. So even though I think his compensation is gargantuan and inappropriate, as he's a shareholder, he's somewhat aligned with our interests depending on when he could dispose of his shares. And hopefully over the next week or two, We'll learn more about the Forster deal and about any other deals, and we can move forward. To all you out there, thanks for hanging out. Have a great day. Feel free to comment when I post this video. And if you have questions, I will respond to your comments and on the questions you ask. And everybody out there, be well, take care, and we'll talk to you soon. Obviously, I'll keep you apprised.